Hello learners, welcome to the third subunit on juvenile justice. Under this unit, I, PALLAVI SENGUPTA, faculty member at National Law University, Odisha, will be dealing with the concept of juvenile justice under the Juvenile Justice Care and Protection of Children Act 2015, which hereinafter would be referred to as the Act of 2015. Now let's understand who is a child in conflict with the law. A child in conflict with the law is anybody who is a child who has been alleged to have committed any crime. On the other hand, a child in need of care and protection includes an abused child, a neglected child, a sexually exploited child, an abandoned child, a waif child, a trafficked child, a child laborer, a child drug addict, a mentally or physically impaired child, etc. Some believe that even a child in need of care and protection includes a child who is a child in conflict with the law. Now let's look at the next concept, which is the best interest principle. This is a governing principle in all matters related to children. It is considered to be a primary consideration when it comes to any child. Before any decision regarding a child is taken, his or her best interest is always kept in mind. Apart from the best interest principle, what we need to understand is the fact that under the 2015 Act, there are other principles which guide the behavior that is meted out to the children. These principles include the principle of equality, the principle of non-discrimination, the principle of justice, the principle of legal aid. Further, it must be kept in mind that the right to participation of any children is a primary consideration again, and this right to participation has to be considered in all matters concerning the child and not only kept in mind when it comes to hearing the child itself. Also, we have to keep in mind that the child has other rights such as the right to dignity, the right to family, the right to safety, as well as the right to privacy and confidentiality. Now let's look at the Juvenile Justice Act of 2015 in detail. When we talk about the Act of 2015, the first thing that we need to consider is the fact that what type of offences committed by the children are to be considered. These offences are categorized under three heads. Firstly, heinous offences, secondly, serious offences, and finally, petty offences. We have to also keep in mind some other factors which include, firstly, that no first information report can be registered except in the circumstances where the suspect child is alleged to have committed a heinous crime or is alleged to have committed a crime along with other adults. Further, we need to keep in mind that post-apprehension, the child suspect must be not kept in a lockup, that is a police lockup. Further, the child under the Juvenile Justice Act of 2015 who is considered to have committed some crime must be produced before the Juvenile Justice Board within 24 hours without fail. Also, informing his or her parents immediately after his apprehension is a must. Further, bail to the child suspect is generally granted and is the norm. Also, the Juvenile Justice Act of 2015 prescribes different procedures for trying a child in conflict with the law who is above 16 years and who has been alleged to have committed a crime which is of heinous nature. Further, no child under the Juvenile Justice Act of 2015 can be given a life imprisonment or a death penalty. Also, correctional facilities must have educational, vocational as well as recreational facilities in them for these juvenile offenders. Now, let's come to the idea of children in need of care and protection, basically children who are victims of crimes. As was discussed in the introduction, children are the hope for tomorrow. while they are innocent and inquisitive, they are also prone to exploitation. They are made victims of abuse at home or forced to work as child laborers. They are trafficked for financial gains or used in pornography. In all the above mentioned scenarios, it is the children who are the worst sufferers. Thus, the Act of 2015 aims to protect these children as well as to punish the offenders. There are various punishments prescribed for these offenders: for treating the children cruelly, for subjecting these children to corporal punishment, for employing child beggars, for using a child as a drug peddler, etc. Further, the Juvenile Justice Act of 2015 also aims to punish the offenders for exploiting the child employee, for indulging in buying or selling of children, etc. As you can see from the PPTs, all these punishments provided under the various heads are aimed to create a deterrent effect. Thus, if the child aims to have his protection guaranteed, he needs to come under the purview of the Juvenile Justice Act of 2015. Now, let's come to the final part of our lecture, which would deal with the landmark judgments, without discussing which we cannot complete the idea of juvenile justice. First, let's deal with the case of Subramaniam Swamy versus Raju. In this case, the act in question was the Juvenile Justice Act of 2000, which is now repealed, and in this case it was stated that the act must be interpreted in such a manner that it gives its benefit to the children who are the intended beneficiaries of the legislation. The age of 18 years, which was prescribed under the law, which is the statute, is the dividing line and must be respected. The aim of this case was also to give benefit of rehabilitation to these juvenile offenders so that they could become useful members of the society later on. Further, let's look at the case of Ashwini Kumar Saxena and the case of Sri Ganesh, in which the Supreme Court gave guidelines regarding how to determine the age of a juvenile delinquent. It was determined that for determining the age, first the documentary evidence would be looked at, and then if still it could not be determined, as a last resort, the medical report of the child could be considered for determining the age of the child. As you can see, children are the most vulnerable group of the society whose interest must be protected by giving benefit to the Juvenile Justice Act of 2015. The government, the society, as well as we all have a duty to protect these children so that their future is ensured, so that they have a good future. We need to keep in mind that these children are innocent and their innocence must also be protected. This is it for today's lecture. Hope to see you all in the next lecture, which is on child marriage.